Hi, everybody, and welcome to Raw Law. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney. So welcome, everyone. And let's get into it. Let's answer some of your questions so we could have a nice session and I can give you some value because that's what it's all about. Our goal is helping serious injury victims and families, and we try to give back and answer your questions and help as much as we can. So let's see what questions we have today. I see the first question is from Virgo Vibes, and she asks, my surgeon who did my kneecap removal says he doesn't know much about my cerebral palsy. Will it hurt my case if my lawyer cannot find an expert who knows much about it either? So I'm not sure. I'm not sure what you mean. Like the surgeon who does the kneecap is an orthopedic surgeon. So of course he's not going to know about cerebral palsy, right? Because that's more of a developmental delay or like a condition that's cognitive, right? So he wouldn't be expected to know about that. You would need somebody like a neurologist or somebody who's familiar with cerebral palsy. Now you're saying you want your lawyer to hire an expert. But what kind of expert are you talking about? I'm not really following, you know what I mean? You mean like a liability expert to prove that the store, this is a store case, right? From what I remember from before. You mean like to show that the store was somehow at fault? But you wouldn't need a cerebral palsy expert. You would just have to get a neurologist to talk about your condition, right? And then perhaps to have the judge charge the jury that they have to look at you as a reasonable plaintiff that happens to have cerebral palsy, right? As opposed to somebody who doesn't, who might be more like, you know, more adept or whatever, more high functioning. I don't know how you describe it, but that's I believe that's maybe what you're talking about. But you wouldn't need like a cerebral palsy expert. Aside from like just a treating doctor, maybe your treating doctor who treats you for the condition. That would be all you need. And then the other question she asks is, today is the deadline for the grocery store to review my discovery responses. My lawyer never updates me. What will likely happen next? Also, is it bad that my lawyer hasn't met me in person? I mean, yeah, I think so, right? I always say that the lawyer should meet the client in person and prep the client. And, you know, in general, it's always a good thing, right? The more communication there is, the better. Because remember, the lawyer is your guide. So the lawyer is kind of like walking you through this entire litigation process, which is like kind of the deep, dark woods, right? He's holding your hand and walking you through the deep, dark woods. So, of course, you want the lawyer to communicate with you, to explain things, to answer your questions, to give you guidance. Otherwise, you know, you're walking through these deep, dark woods with a stranger who's not even talking to you. So he's kind of like leaving you in the woods alone. That's not good. And then your other question about what's going to happen after discovery. Well, discovery is like kind of a broad topic, right? So discovery includes paper discovery, meaning you provide information to the other side, to the defendants, about your medical treatment, usually in the form of authorizations. Then what they do is they use those authorizations to send a letter to the doctor, and then the doctor gives the defendants a copy of your medical record. So that's going to be discovery. Another big part of discovery is depositions. So they're going to ask you questions like, what happened? What's your injury? You answer those questions, and there's a transcript. The court reporter types up a transcript, right? So that's a big part of discovery, and that has not happened yet. It sounds like that's going to happen in the future. So that's usually, and then once all that is done, then you could say, well, we finished discovery. Now we're going to take the case and put it on the trial calendar, and then you get a trial date a few months down the road, or it could be a few years. I don't know, depending on your jurisdiction. In New York, sometimes it's even a few years, you know, because you wait, like in Bronx, you wait like 4 years. But in, you know, I forget which state you're in. I think was it Alabama? Maybe in your state it's quicker, you know, because there's fewer cases. I'm not sure. Okay, and then Willie is here. Willie says, good afternoon, Mr. Arkady. Question, my lawyer said I have to do an interrogatory. What's next after that? I'm in the last of the discovery phase. Thanks, my friend. Yeah, so if you have to answer interrogatories, it just basically means that you have to answer some questions. Like usually they're pretty simple questions about like what happened or about um, your injury. So you have to read the interrogatories and your lawyer should help you answer. After that, it just depends. If you've already had your deposition, you may not need to do it again. If you have not, then you may have to still do a deposition. In New York, we don't really have interrogatories. I mean, we can, but then if we do the interrogatories, then we will not do the deposition. So like almost everybody, 99.9% just choose to do the deposition because the deposition is better because you get to speak to the witness, ask questions, get their answers. If you don't like an answer, right, or you don't understand an answer, you can ask another question. It's live. You do it on Zoom or you do it in person. Now, with an interrogatory, you write the questions, you send them in a letter kind of, and then they just write the answers back. So, if you don't like an answer, there's nothing you can do. You have to do another set of interrogatories. It's very kind of like snail mail, it's very cumbersome and long-winded. So in New York, you can't do both. You just choose. So everyone just chooses depositions because they're better. Okay, and then Israel says, good evening, Mr. Arkady. I hope all is well. What's the best way to describe what you cannot do anymore without making it an absolute when talking about damages? Any pro advice, please and thanks. So you're basically saying what you cannot do, but without making it like absolute that it's whatever you can do, right? Because it's going to be different for every person. What I like to sometimes advise people is to look at a day in the life. So for example, you did not sleep very well. You did sleep, but you didn't sleep very well because you're in pain, because you were tossing and turning, you were waking up, you couldn't fall asleep. Then you get up in the morning and now you're very tired, you're not well rested. You get out of bed, you may want to go take a shower, but it's hard for you to do that because you have to bend down, wash yourself. Then you want to get dressed, right? Dry yourself off, get dressed. You have to bend down, put on your socks. You can't do it because you're in pain, right? And just keep going. What else do you have to do? Go down the stairs, up the stairs, get a cup of coffee. If you have a shoulder injury, you can't reach the shelf, whatever it is. And just keep going through from when you wake up until when you go to bed and talk about how it's affected your life. Now, if there's anything specific that you really like to do, like for some people, maybe you play baseball. Now you can't play baseball. So talk about that. Tell a story, right? Why that's important to you. Could be things like playing with your kids, playing with, like doing things with family members, whatever is important to you. Like you have to ask yourself, what's important to me? What do I love in terms of activities? And then who do I love in terms of relationships and who's important in your life? And then go into that. But I always think like stories are good, moments in time are good, because everybody says, I can't sit, I can't stand, I can't walk. It's just, you could do that and be like the 100,000th or 100 millionth person who said that, right? It's not going to make your case any different. It's not going to make your case any more valuable. But if you tell like an actual personal story or moment in time, then it's much better, right? Because that's real and it shows that it's really affected you. So things like that, Come along with Uncle Joe says, hello. Hi, how are you? And Jeff Martinez says, good afternoon. My lawyer and I will have a deposition in 2 weeks. They recommended surgery and I have videos and witnesses. What is the possibility of closing the case after deposition? Yeah, there's a good possibility. It really depends on how much they offer you and whether you're happy with that number. Remember, you can close the case at any time. You can close it before deposition. You can even close it before you file a lawsuit. It's just, if you haven't closed it yet, it probably means either they haven't made you an offer or that they have not offered enough. So you just have to, if you do a good job in your deposition, then your lawyer can call them up and say, look, my client's injured. It's completely your fault. He's recommended for surgery. And we have like videos, we have witnesses, we have all the proof. So, pay us X and then see if they do. And if they don't, then you just have to be ready to continue pushing and go to trial and get more in trial. And then Sarah says, hi, Attorney Arkady. I've had an open personal injury case since March, and I've only spoken to my attorney once over the phone. Should I wait and see how he communicates or look for a new lawyer? It's hard for me to say, it really depends. Like if you're not happy with the communication, if it's been like since March and they haven't been communicating with you, you might want to reach out, send them an email, a text message, whatever communication is available. Go to their office, say you want to make an appointment. But if they're not really communicating and they're not helping you, then you could text me, 347-566-9595 and let me know about the case. I could help you find a new lawyer if that's what you need. I know a lot of the best lawyers all over the country. So I could find you a trial lawyer who's like real, passionate, who's a trial warrior who goes to court, depending on where you are, and help you with that. And then Burnt says, good afternoon. Quick question. Please explain motion in limine. The lawyer put the motion in. Should we be afraid? No, a motion in limine just basically means that they want certain evidence excluded, right, for a trial. So it depends on which lawyer put in the motion and what was the relief being sought, right? So it's pretty standard. Like, for example, if there's a case where, for example, a plaintiff has a prior criminal conviction or a prior criminal arrest, and that you think the defendant may try to use that, right? So then the plaintiff's attorney could file a motion in limine to say, like, that is excluded and have the case law and the precedent and the reasons why. And then the judge will make the decision either to exclude that or to let it in, right? So that's usually how that works. It's just a motion where you want certain things excluded from the trial, certain things that would not be admitted in evidence under the law. So it's not really anything to be worried about. It's just a standard thing that happens in almost every case. And then baby boy Jody says, hey, buddy, I got 2 IME appointments next week. And my, let me see. And my discovery date is over December 1st. What's next for me? So once the discovery date is over, you go on the trial calendar, and then you're going to have a trial date. So you're moving along, and the case should be resolved pretty soon. So it's good news. And Miguel Angel Lewis says, hello, Arkady, because before putting your case on the court calendar, it is mandatory to first have appointments to see if you could reach an agreement, conference to reach an agreement. Well, that depends on the court. Sometimes, you do have to have like a mediation or a settlement conference. At other times you don't. It really depends on the court. Usually they do try a settlement conference, but nothing's going to really change in the settlement conference. Probably your lawyer has tried to negotiate with the other side, either by calling them up, right? Calling the adjuster, calling the defense lawyer, sending a settlement letter. So if that hasn't worked, just the fact that you have a conference, now it's the same thing, but it's just in front of a judge in a courtroom. They're not suddenly going to say, well, now we're in front of a judge, here's millions of dollars, right? If they haven't given it to you yet, and you're already almost at the point where you're certifying as trial ready, you're probably a few years in. So it's not going to really change much usually. And then Virgo Vibe says, cerebral palsy is neurological, but it also affects my mobility. My diagnosis isn't so much cognitive. Oh, I see, right. So yeah, it does affect mobility as well. Yeah, so you just want your doctor, your treating doctor for the cerebral palsy to testify and explain the condition and all the ways that it affects you. And then, your lawyer can then tell the judge, well, so when we have to look at this particular plaintiff, we can't look at her as just a normal person like every other person, but it has to be, what is reasonable care for somebody with this condition, right? I believe there's a pattern jury instruction. I don't know if it exists in Alabama, but I believe it does exist in New York. So just like if it was a child, right? So it wouldn't be like a 40-year-old, it would be like a reasonable child. Or if it's I'm pretty sure they have one in New York for an intoxicated person, somebody who's really drunk. So you say, well, it's reasonably intoxicated person, something like that. So it's basically whatever condition you're under, they look at you with regard to how reasonable it is for somebody with that condition, as opposed to somebody who doesn't have the condition, right? And it's just whatever's reasonable. I'm assuming you mean that you're worried that you are going to be found at fault, right, for falling. So if that's what you're talking about, then I would have that jury instruction included. That would help you. And then Willie says, good evening, Arkady and everyone. Good evening. How are you? And Corey says, hey, Mr. Frekhtman, hope all is well. Can't wait for us to get this show on the road. CJ. Oh yeah, definitely. Let's do that. Let's do a show. We could talk about some cases, some examples. That'll be awesome. Let's do that. Yeah, just text me. We'll try to get that scheduled over the next few weeks. And then Chris says, thanks for all the videos. You helped me get a new lawyer in Las Vegas over a year ago, and they are doing an outstanding job. Oh, that's great. I'm really happy to help. I'm really happy to hear that. Yeah, I try to, help as much as I can, get people lawyers. Like I could do it all over the country almost. And actually, I was at a conference last week, a law conference, and I learned a lot of new things, like what people are doing. And on the bigger cases, if you have like a brain injury or a fusion or anything like life-changing, where it's a forever injury, some lawyers, what they're doing is they're showing the case in like a neutral statement from the plaintiff and from the defendant to then a focus group, right, with kind of like scientific analysis, right? These scientists do that. And then you get the results back from the focus groups, but they don't show it to just like, say, 6 people, but they show it to like thousands of people. And then the results really help you because hey, what should I ask a jury, right? In terms of like, when I tell the jury this case is worth X, should I tell them it's worth 10 million? Should I tell them it's worth 1 million? Should I tell them it's worth 50 million? So they actually tell you, hey, if you tell them it's worth 1 million, you'll get like 200,000. But if you tell them it's worth 10 million, you might get 2 million. And if you tell them it's worth 50 million, you might get 16 million. And then it says, and your chances of success at each level, right? So if you say it's worth 1, your chances of success are like 70%. But if you say it's worth like 10, maybe that's too much, your chances go down to 50, whatever it is. But actually what I saw, of course, it's not all across the board, but what I saw was that the chances of success actually sometimes increased the more they asked, as long as it wasn't like crazy, right? As long as it was within the realm of possibility. It actually increased. So asking for more seemed to be better, and people were getting good results. So yeah, so there's a lot of like new things that are happening. I want to start doing that on some of my cases as well, although it's expensive. So we have to figure out a way to either maybe partner with those lawyers that are doing that, or maybe pay per focus group. But it could definitely be worth it. And then JC says, hi, Mr. Arkady. Not sure if you remember, I'm the 23-year-old with TBI from a concert. I was offered a settlement in the very low 6 figures. What can I do? All the other attorneys have turned down my case. Yeah, I mean, you just have to like see if you could find somebody, because I remember that you're in a concert and you had the TBI. So you have to ask them why they're turning it down. And if they can't help, then I guess you just do your best to try to find somebody to help you. You could text me. I could try to find, I think I did try to show it to a few lawyers, but I forget why they turned it down. But if you can't find anyone, then you may have to just accept the settlement. I guess it's better than nothing. But yeah, I mean, I wish I knew why they're turning it down or what the issue is. It might be some kind of issue with that particular case, or because that might be more of like a class action type case. I'm not really handling that, so I don't know. And it's in a different state. But I could try to maybe find 1 or 2 more lawyers for you to try to help you. But yeah, definitely, you just have to ask them like why they're turning it down. And maybe since you have a lawyer now, you could also ask your lawyer, right? Ask them what's going on. Basically what's going on with my case. Give me an update. Am I able to sue for more, or do I have to take this settlement? And Zafraz says, hey, sir, I have a pretrial conference in December. What normally happens there? Insurance didn't make an offer as of yet. Yeah, so a pretrial usually is just basically talking about the trial, what's going to be done in the trial, what's needed, and then you get the actual trial date. And then he also says 30 million insurance policy, lumbar laminectomy, left shoulder surgery, injection in the neck, back injections, 5 million demand. Insurance also filed a motion to dismiss. Mm-hmm. Yeah, so I mean, you just pretty much, it's just like the pretrial is just like talking about the trial, like how many witnesses, what's going to happen at the trial, everything about the trial, kind of like preparing for it, and then you have the trial. So the next step sounds like it's going to be the trial if they're not settling. And then Kali F. Cool says, hi, Arkady, is Uber UIM supposed to cover a passenger if the car truck has insurance coverage? I'm not sure. So you're saying Uber you're a passenger in the Uber and the truck has insurance? I mean, it depends who's at fault, I guess. But like the way works is if you're suing the other car and the other car was at fault, and then you take everything that they have. Like, for example, let's say they only have 25,000. And then if your car, the Uber, has more, you can get the difference from your own car. So for example, let's say like an old beat up 1985 Datsun rear ends an Uber. Well, obviously the Datsun's at fault, but all they have is 25,000. So you take the 25 from them. And then if Uber has 1 million, you can get up to 975,000 more from the Uber or whatever the coverage is. That's my understanding of how it works. And then Kali F. Cool also says, I switched lawyers, but my new didn't know that they didn't add my driver into the lawsuit. So now he's trying to pull back in. The new lawyer didn't know that somebody didn't add a driver. Well, I mean, yeah, you have to sue everybody, basically you have to sue everybody that's involved, like the driver, the owner, obviously that's just like, yeah. So then, yeah, if they didn't sue them, then you just add them in now if you still can, if you're within the statute. That's important because, yeah, if you don't sue somebody, then they're not in the case. Then if the jury says, hey, that guy's at fault, well, he's not in the case. So then you're not going to get money because he's just like, out there, not in the case. That's not good. So you definitely have to sue everybody. And Money Dog says, what do you do when you have an attorney that tells you he's going to do something and he never does? And I'm the babysitter that's gathering evidence as well as he likes to lie a lot of times. Well, I mean, look, just use your common sense. If he's not doing what he says he's going to do, that's not good. And if he's just, you have to babysit him and he's not really helping you, maybe you have to look for someone else then to help you. It's basically, it's just common sense, like anything, right? Like, what do I do if I go to a doctor and the doctor doesn't want to talk to me, doesn't give me a diagnosis, and I say, hey, doctor, but I'm feeling really bad, I need help, and he says, I don't want to help you. What do I do? Go to another doctor, I mean, it's just like common sense. I don't know. I can't tell you, right? I don't know your case. I don't know how far along you are. I don't know like what relationship you have with this lawyer, so I can't tell you. But it's just like whatever you want to do, you have to make the choice. And then Sani says, hey, Arkady, thanks again for the other day. Oh, yeah, you're very welcome. He says, Arkady was my attorney for my PI case, got me way more than what my prior law firm said I'd get. Oh, yeah, of course, yeah. Yeah, Sani was unfortunately with one of these like mill firms. They were just trying to like settle it for like a low amount and get rid of it. And we filed a lawsuit. We worked it up. We showed the liability. We took depositions. We put it on the trial calendar, and then we settled it for a big amount. But I was actually trying to get him more, but he wanted to settle. I thought I could have gotten him some more, but you never know. It's kind of like at some point people don't want to like maybe wait anymore, or don't want to gamble anymore, but that's okay. I think we got him a pretty good result. And then a car says, hi, Arkady, how does a 5% permanent disability rating affect a case? Grade 3 ankle sprain, does it increase the case substantially? Future loss of earning capacity, can that be included? Yeah, I mean, I don't know if you're talking about a workers' comp case or a personal injury case. So if it's a personal injury, then of course, yeah, if you have loss of earning capacity or the ability to earn money, that should be included with an economist expert. And then, yeah, grade 3 ankle sprain, it has some value. Now, you don't have percentage impairments in personal injury unless you're talking about like something else like SSI disability, or maybe the workers' comp finding that it's a 5% impairment and whether that gets translated into the personal injury case. I don't really deal with those percentage impairments, so I couldn't really tell you about that, or disability ratings. But a grade 3 ankle sprain, I mean, it has some value. It's a sprain after all, so it should heal and go away. So it's not huge, but yeah, I definitely include future earning capacity. And Benito says, what would be the next step after a motion to compel? Yeah, so if you're moving to compel, depends on who's making it. If it's a plaintiff, basically you're trying to get something, right? Compel them to do something, compel them to take a deposition, to produce a witness, to provide document discovery. So usually the next step after that is the judge will rule on the motion and either say, hey, I'm compelling this, you have to provide this, and then you get a court order, and then you just follow the court order. So it's pretty straightforward. That's usually, basically, there's not really any other step, right? Because you've already made the motion. So you just have to wait for the court order, and then you just follow the court order. And then let's see, Free Band says, is 3 million crazy to ask in a slip and fall case? I broke 3 bones and fractured my ankle. I mean, no, it's not like crazy. You could definitely ask for that. I don't know if you'll get the full 3 million depending on which bones and how bad the ankle fracture is. But if it's open reduction internal fixation, like ORIF, with a fractured ankle plus 3 broken bones, it could be worth into the millions. I don't know if it's 3 million, but it could be like 1 point something, depending on where you are. Also, like we had a case we got 3.5 million on a slip and fall, but that was like with a major fusion surgery, a back surgery. And Desiree says, I've been trying to get a consult with you. Oh, yes. I'm sorry. I was supposed to call earlier today. I'll give you a call. See if I can do it today. If not, maybe tomorrow. I did another consult today. I had another one scheduled. So I just got a little busy because I have a trial coming up. So I was preparing for the trial. So I didn't get to do too many consults, but I did get one in today. And then Jeff says, if I sue the company, can I return to work afterward, even if the agreement was made through Section 32? And if the doctor tells me that the surgery was successful and that I was a good employee? Yeah, I mean, I think so. But if you sue the company, you're not going to sue your employer because that's workers' comp. You can't sue your employer. You get workers' comp benefits from your employer. So if you're talking about a Section 32, then that's with your that's an agreement you make with workers' comp. That's a workers' comp settlement. So you're not suing your employer. You're making an agreement with the workers' comp insurance carrier. So it's the insurance carrier for your employer that pays out the workers' comp benefits, which are things like lost wages, get your medical bills paid. So that's what the Section 32 is. So I think you can return to, I'm not sure, I don't do workers' comp. You'd have to ask a workers' comp lawyer, but I think you can return to work if, I don't see why not, if they'll take you. So yeah, I don't think it's an issue. But don't hold me to that because like I said, I don't do workers' comp. So I would just maybe confirm with a workers' comp lawyer. And then Frost Midnight says, why the insurance company offers $300,000 on a trucking case but has $1 million policy, and you turn it down because psychology and nightmares every night, even back problems prevent me from working. Why they ask for your social media accounts, login and password, and I don't want to give it to them if they don't have anything on me. Why should I have them looking through my social media? It's not fair to the injured person. He didn't cause his life to be like this. Yeah, you're right. I mean, you can have your lawyer fight it. Basically, what they're asking for is to be able to look, because some courts will say, well, if you're posting it on social media, that's kind of like public. So therefore, they want to see, hey, if you're out there on social media saying, I could do a dance or whatever you're doing, right? I can go skiing, I could do activities. Then they're going to say, well, look, he's trying to say that he's injured, but in reality, look at his social media. But you have to speak to your lawyer to see if you have to give them the login and password. What I recommend is, look, if you have a serious personal injury case, just don't post anything on social media. Maybe just don't have a social media until the case is over. Or, some people say make it private, but you see, make it private, they still ask for your password. Depends on the judge, if the judge compels that. I think that if it's not out there in public, if it's just private, then it's really more like you have a photo album, like right in your house. It's yours. It's like a private diary. They shouldn't be able to access that. But, some other judges might see differently. So it's better to be safe and just like not let them into that, because unless there's nothing there, right? If you're really hurt and you have like a serious trucking case with $1 million policy, and you're saying you have like nightmares and serious injuries, then probably you didn't post anything crazy, so then there's nothing to worry about. And then Duke says, hey buddy, hope you're doing well. I talked to you before about my case. Looks like 2 more epidurals, then surgery to burn off the nerve endings before the back surgery. Hopefully will make my case worth more. Yeah, definitely. If you have epidurals, that's going to make the case worth more. And if you have the ablation, I think you're talking about ablation where they burn the nerve endings, that also increases the value of the case for sure. And then my medical bills will be over the policy limits, I'm sure. for Geico. I appreciate you for helping all of us. Just wanted to say thank you. Oh, you're very welcome. Yeah, thank you for reaching out and for staying in touch. Absolutely. And I wish you all the best in the case. Hopefully you get full justice. That's what it's all about. And then Ray says, how can spoilage of the vehicle by the defendant help a case? Well, if there's spoliation, meaning like, for example, if it's a truck crash and then you send them a notice to preserve the truck, for example, if the brakes failed, right? So you want to have your expert examine the brakes. But then despite getting your letter and knowing about this litigation hold, they go ahead and they fix the brakes, or they destroy the truck. They say, we don't have the truck anymore. That could then help your case, because you could make a motion to say, well, they got rid of evidence. That's called spoliation. They spoliated the evidence. So then the judge could sanction them and say, well, now you guys can't produce any evidence as to the fact that your brakes were safe. You're precluded. And then the only evidence will be the plaintiff to say the brakes were faulty, or they could even strike their answer or make a finding of liability, or whatever the judge wants to do. They have a lot of discretion in that regard because they got rid of the evidence, right? You can't get rid of evidence like that. And then Tony says, hi, super lawyer, 2 million policy commercial, slip and fall parking lot, post-concussion syndrome, hearing loss, tinnitus, diagnosis, long-term 2 years symptoms, knee arthroscopy, surgery, clear liability. Thank you. Yeah, that sounds like a good case. If it's a 2 million policy, it's a slip and fall in a parking lot, as long as you have the proof of the liability, right? Whatever caused you to fall, like there's a hole or there's a unsafe condition, you want to be able to prove that. And then post-concussion syndrome is serious. Post-concussion syndrome is kind of like a traumatic brain injury. Now, some people call it mild, but actually in the late 2024, they updated the guidelines. And right now, there is no such thing as mild, right? It doesn't exist anymore. So it's a traumatic brain injury. And if you have tinnitus, that's ringing in the ear, you have hearing loss. So that's serious. That could be a huge case. They should probably give you the full 2 million if it's a real brain injury. That could be a big case. And Israel says, is it common for recommendations to a neurological evaluation 2 years after a serious injury? Yeah, you could. I don't know what you mean. Do you mean like a evaluation by a defendant, or do you mean to have your lawyer send you somewhere, but 2 years later for the neurology? Brain injury, if you have it from the accident, you could start treating at any time. If it happened back then, even if you start treating 2 years later, if it's a brain injury, that's fine. You don't have to go like with a back injury, or you have to go right away. If you go like 2 years later, they're going to say, well, how do I know you didn't fall somewhere else? With a brain injury, it's okay to start later, but it just depends on basically it depends, but I'd have to know a little bit more. But I think it's okay if you're talking about yourself. If you're talking about the defendant, the defendant, of course, is going to send you to the IME whenever that's going to be like 2 years later, because it takes time. You have to be at that stage, basically. And Corey says, I just transferred over to you. Okay, great. That's good. Yeah, we'll do a good job for you. We'll get the case worked up. And Israel says to be recommended. Is it common to be recommended to a neurological evaluation? It's not really like common. You want to probably do it earlier, but like I said, with a brain injury, you could do it later if it's a brain injury. And then Duke Boy says, do you have set days you go live, or just when you get time? That way I can catch your videos. Yeah, usually we try to do it like, once or twice a week. I'll try to make it a schedule. Sometimes we mix it up. Like today, I was away last week, so I felt like, I haven't done a video in a while, so I wanted to get back to everybody as soon as possible. Even though I'm a little busy, I'm preparing for a trial at the beginning of November. So I was actually working on today. I met with the client. I also did some work for my trial. I went over it's a traumatic brain injury case as well. So I went over some of the medicine. I prepared a whole direct exam of the neurologist, which is really good. I thought it was really comprehensive. So I went through some of the medical records and prepared and then I also was working on voir dire, which is jury selection. So I have all these. I have my last voir dire for my last brain injury case. I'm going to review those notes. But then I think, this one's a little different. So I have a bunch of new ideas. I have notes I kind of use, sometimes I listen to like podcasts. They have interesting podcasts about voir dire. They have one called Picking Justice with these two, a jury consultant, his name is Harry Plotkin, and then another lawyer named Dan Kramer. They're from California, but a lot of the things they say, it applies to New York as well. It applies to anywhere. If anyone's interested, you should watch that. It's really interesting. They have this one episode with this lawyer that I kind of know and respect, Arash Hamanpour. I thought that was a good episode. And then they have other episodes with other, sometimes they just talk, the two of them, right, without getting other guests. Sometimes they have guests. They had this one with Randy McGinn, who's a famous female lawyer out of New Mexico. They had a bunch of ones. Joe Freed, he's an excellent lawyer out of Georgia. Actually, I think I recommended him to one of the YouTube viewers, and he ended up getting that viewer like close to 2.5 million on a trucking case. He's a really good trucking lawyer out of Georgia. So anyway, all these different things. So I have all these notes I take. I use like this Kindle Scribe, so I have notes. And then I was going to go through my notes and kind of like see if there's anything I want to use in my voir dire from those notes, because it's like, a lot of information. So when you listen, you get all these ideas, but you have to like synthesize it. And so that's very interesting, I think. So maybe I'll do a video about that if people are interested, about jury selection, about how to expose bias, how to get people off for cause. I don't know if that's maybe a little too much of a trial lawyer show, as opposed to because I know most of the people here are people with cases, not like lawyers. That might be a little bit more like for trial lawyers, but I'm always interested in that. But yeah, and let me know like what videos you want to see as well. If you want to see a specific topic, just let me know. I'll do a video about that topic. I want to shoot a few more about verdicts for sure, because there's some interesting verdicts out there coming up. And also maybe, I know the two biggest questions seem to be, how much is my case worth? And also, how long is it going to take? Basically, how much am I going to get and how long is it going to take? But it's hard to do videos about that. I mean, of course, you could talk about like things, right? Like, for example, the plaintiff, whether they're likable, what venue you're in, how's the liability, how bad are the injuries. Those are all things that determine how much your case is worth, right? The more serious the injury, the more it's worth. The better the liability, the more it's worth, right? The worse the liability, if you like tripped over your own shoelace, well, now it's going down, right? And the same thing, like if you don't have an injury, you're not going to a doctor, well, it's not going to be worth as much. If you're at a conservative venue where people don't give much money, well, then you're maybe out of luck. So those are like the factors, and I've done videos about that, but it's hard for me to say exactly how much your case is worth, right? Because I don't know your case. I'd have to like sit down and read your file and really do a deep dive into your case. So that question is probably better asked toward your lawyer. Your lawyer should give you some kind of an idea about that. And then Leroy Smith says, wish me luck. I have my deposition tomorrow. 2 herniated discs in my neck, 1 in my back, from a rear end, multiple injections and procedures to my neck and back, plus 2 discectomy surgeries and a 1.5 million policy. Yeah, absolutely. Good luck. You should do fine. Don't worry about it. The main thing with these depositions is just to stay cool, just listen to the question, answer the question being asked, and that's about it. I mean, with respect to the herniated discs, just try to understand what that is. You could even Google it or go to like ChatGPT, understand what it is, just so you could explain it. I have these herniated discs. This is my understanding of what it is. Of course, the doctor will explain medically what it is. You don't have to know that. I'm just talking about what my understanding is as to what it is, because it's in my body, right? I want to understand what it is, and also how it's affecting me, right? How the symptoms are affecting me and my life. So, and it's a rear end, so obviously you're not at fault. Just you were stopped for whatever amount of time, 10 seconds, boom, they hit you in the rear. It's their fault. And and the discectomy surgeries, that's pretty serious. So that could be a big case. And Israel says, my mental health doctors for the injury recommended after months of signs of cognitive issues. Oh, I see. They recommended you for a neurological workup. Yeah, that's fine. You should get that done. And then Frost says, how do law firms fight for fair compensation, basically policy limits? What's the client want? How do lawyers have the strength and resources to fight against such big opponents and cooperation? Well, that's how they do it, because basically law firms, what they want to do is, if they're working up the case properly, and they know that, hey, why should I settle there's different types of law firms, right? Some law firms are just based on that model where they say, well, I'm just going to like put up billboards. I don't want to go to court. I just want to get a bunch of cases, and then I'm just going to call, and I'm going to get like 20,000 on this one, 10,000 on that one, and I'm going to make money that way. That's more of a volume practice, kind of like a mill, right, or a factory. Other lawyers might say, I don't want a lot of cases. I just want like a few cases, but I want really good cases, like a trucking case, serious injury, fusion, brain injury, and I want to really build it up. I want to take it to court. And if they offer me like 100, 200, 300, I'll say no, because I want to get like 3 million. I want to get the whatever, maybe even 10 million. I want to get the maximum, the absolute maximum. So it's just the way that the law firm is. So what I'm saying is, if you have one of those cases where somebody can get you, millions and millions, you don't want to be in the wrong hands with one of these billboard guys who's just going to call and be like, oh, 20K, okay, let's just settle it or whatever. So you just want to be in the right hands, basically. You want to have one of those trial lawyers if that's what your case deserves. Like these guys who do these data studies, they were talking about a case just came down out of Colorado, actually at a conservative town, like a small town. And it was like some kind of crazy amusement park ride that went wrong. And they kept checking, and a child wasn't like seatbelted in, and she fell off the amusement ride. It was one of those where they've plunged down and she died. And they got like a $205 million verdict. And they had the data, right? They ran all those data studies I was talking about with thousands of people. So they were told, hey, this is what for the best chance of success, ask for this. So they asked for a lot of money, and they got a $205 million verdict. So it's crazy. So that's an example, right? They go to trial. Another lawyer might say, well, let's just settle, even if they got a few million. So it just depends on how, who's doing it. But yeah, definitely, you want to be in the best possible representation that you can get. And Leroy also says, plus annular tears, 1.5 policy. The defendant didn't even show up to his own deposition. My lawyer said that's a good thing. The insurance company is not disputing liability. Yeah, so you should be able to get the policy. If they're not disputing liability, you have 2 discectomies. That's a serious case. And Paul says, hello, Arkady, can you receive compensation if you have underinsured insurance? Underinsured? Yeah, I mean, you can. Underinsured, I'm not sure what you mean. Underinsured insurance? I'm not sure what that is. Underinsured, like you mean like uninsured or underinsured? It's like I explained before, like I explained it in this live. Basically, it's like if you're suing the defendant and the defendant doesn't have enough, like they only have, let's say, 25, right? So you take their 25 and then you go under your own to get more if you have more, but you have to have more than the other guy, right? That's you go under because you have more uninsured. If he's completely uninsured, it means he has no insurance, then you go after your own. But if he has some insurance, like 25,000, but you have more, you have 100, you can get the difference from yourself, like 75. And then Stomper says, hello, hi, how are you? And Duke Boy says, I forgot to mention a week ago I had a seizure that put me in the hospital. My wife had to call the ambulance. It was a scary situation. Couldn't walk or move with all my spine injuries. It had to be a part of why. Yeah, no, I'm sorry to hear that. Yeah, absolutely. So you should add that to your case if that's caused by the underlying incident. And then DND says, I fell through a floor at a hotel, dislocated my shoulder, 3 anchors, 2 million policies, Hartford and Miami. We are in the discovery phase now. They did offer $275,000 pre-suit a couple of months ago. We haven't told the defense that I know about a quote that was given for $300,000 to replace the floor 2 weeks prior to me falling, and the CEO decided not because of cost. Oh yeah, so that's a strong case. Yeah, definitely, you can definitely win that one. And then Duke Boy says, it happened since I have no history of it. What range does that affect a case normally by the amount you have gotten in cases? Thanks, buddy, for listening. If you have email, please let me know. Appreciate you. Yeah, well, you can just text me, 347-566-9595. We could do a call. I'll try to help. Just the seizure, I mean, depending on how bad it is, if it's like if it's like one time and you went to the hospital and it went away, it might not be as much as if it led to some kind of permanent, long-lasting diagnosis. Anything permanent is usually worth much more. And D&D also says, and 2 days after I fell, he replaced the floor. Does this increase the value of the case? Yeah, definitely, because if he's putting profits over safety, right, he's like not wanting to spend money. So yeah, absolutely. I think that's a very powerful on liability and damages, and you have bad injuries. So I think you should try to get much more. You could try to get into the closer to $1 million or maybe even over $1 million. And Stephen Barrett says, do insurance companies like to settle before the end of the year? What's the benefit for them? Yeah, they do. The benefit is that they get to write it off their taxes, right? So it's like a write-off because they make a lot of money. They probably make billions in a year, right? So if they're going to pay the claim. They look at it this way: well, we're going to have to pay the claim anyway, right? Because it's a legitimate claim. So why not pay it now? Then we get a write-off. So if we make like $1 billion, we pay all these claims for millions and millions. Now our taxable income is less, as opposed to if we didn't write it off, we would just pay the money to the government anyway, right? And then Stomper says, if the unfortunate event were to occur, hypothetically speaking, I get into a second no-fault crash, what happens to the injuries and surgeries of the first case? Can I sue for OG injuries and exacerbation because of the second crash? Does the first case get ruined? No, I mean, it doesn't get ruined. You just have to kind of separate them, right? So whatever's caused by the first crash, you still sue and you get paid for that. And whatever's, if you have a condition already, because at the time of the second crash, you already have these conditions, whatever injuries you had from the first incident, right? So what happens is it's to the extent that those conditions were made worse. So let's say the first incident gives you a herniated disc at L5S1. So when you have the second crash, you already have the herniated disc at L5S1. So you can't say, I want money for the herniated disc at L5S1 from the second crash because you already had it from the first crash, right? So you can't do that. But if the doctor says, well, this L5S1 herniation is really bad now. Before you were able to live with it pain-free, but now you need an injection for it, or now you need a surgery, like a discectomy for it. So all of that, what you need to do for it because it got worse is now from the second case. You see what I'm saying? That's how it works. So it's to the extent that the injury was made worse. And then whatever was from the first case stays with the first case. But sometimes it gets like all muddied up and it's hard to figure out, right? Nobody could figure it out. So in that case, you do your best, you settle it. Generally, it just depends on the specifics of what they found, where they found it. Sometimes the other thing that happens is in the same example, right? If it's an L5S1, but then they say, well, but now there's also an L4, L5 bulge or herniation, right? And that's obviously, you didn't have that in the first crash. That's from the second crash. So the fact that you were weak at L5S1 makes you more vulnerable to have an adjacent segment like herniation or bulge from the second crash. So that's from the second crash. So that's usually how that works. And then D&D says, the defense says they are looking into an engineer that gave approval to occupy the premises 30 days prior to the fall. Will that affect my case? An engineer that gave approval? I mean, I don't think so. Well, how would that affect it? I mean, if they knew they had to replace the floor, they didn't replace the floor, I think it's a slam dunk case if they were given the quote. I mean, you could occupy a premises, but like occupying just doesn't mean that you could have an unsafe floor, right? You could have a certificate of occupancy for any premises. A certificate of occupancy just means that the premises is like done, right? And it can be occupied, but you still have to make sure that the floor is safe and, basically everything is safe, right? Like, any incident that happens in a building that's already in existence has a certificate of occupancy, but that building could have a hole in the floor, or it could have ceilings collapse, or just have like a puddle of water that shouldn't be there, right? So I think you're fine. That doesn't really matter, I don't think. I mean, what are they going to say? That the guy did such an inspection that he inspected every nook and cranny of the building and said, this is a pristine building, like nothing could ever happen here? I wouldn't really worry about that. Yeah, so I think you should be okay, because floors in hotels shouldn't have, the floor should not have a hole that you fall through if you're just walking on the floor. So I think you should be fine. And Israel says, got into an accident, got a text Frecht. And Stomper says, what if the at-fault driver denies to take a deposition? Doesn't it delay the case a lot? Well, no, if they don't show up, you just make a motion and the judge just precludes them and then they're out. And then basically it's your word and they don't get a deposition. You can't just, you could delay. You could say, I'm not ready, whatever. I have an emergency, delay 2 weeks, whatever, a month, 2 months. But you can't just deny showing up. If you deny showing up, then you basically lose. And then you just get, it's just your word versus nobody. There's nobody else. So you win, or they could even be precluded from testifying. And Nikisha says, did you see my question? No, I don't think so. Let me see, Nikisha. Was it in this chat right here? Let me see. I don't think I see it. If you could send it again, I'll be happy to answer. No, I don't think I see that one. Maybe I missed it, or maybe it didn't pop up. Because I'm going through the questions. I don't see that one. Yeah, I don't see Nikisha. And then Max says, my law firm is giving me $1,000 a month. Does that mean that they believe I'm going to get a decent settlement? They've been doing it for over 6 months. They also pay for my hotel, travel to the dock. I'm not sure. The law firm's not really supposed to be giving you money. Maybe what you mean is they're getting you funding. Maybe they're working with a funding company. The funding companies, they're like outside companies, third parties. They can give you money, but you have to pay that back at the end of the case. And some of them charge a lot of interest. So if you're getting, let's say, $1,000 a month, that's like $12,000 a year. Just make sure the contracts are capped so that, you know, they could say, okay, we gave you $12,000 a year, but we're going to take back, let's say, 24, or we're going to take back even 36, but not like, you know, uncapped, because uncapped could be we gave you 12,000 and we want 100,000 back, right? And then it's crazy, and then you're going to get really, you know, it's not good. Yeah, and he also says, wish I would have found this guy before hiring a lawyer. Lawyers that communicate are gold. Oh, thank you so much. I appreciate that. Yeah, but I think, you know, but in general, it's a good sign if they're getting you funding, if they're also paying for your like travel and hotel and docs. That means they probably think you have a good case, right? Because they have to put all that money up front. And the reason they do it is because they probably think, well, we're going to get it back later, right? You don't want to put up a lot of money and then say, I'm never going to get it back. That's not a good business model. So, and then DND says, is it normal to go from depot to mediation, or mediation then depot? You know, it could be either way. Usually you get a deposition first and then a mediation, but a mediation could be done before a deposition if the case is so clear and the parties think that a mediation could be fruitful and might lead to a settlement. You could even do a mediation before a deposition. And then Virgo says, even if the video footage of my fall is unclear or unfavorable, isn't it my lawyer's job to best defend it? Yeah, of course. Yeah, your lawyers, of course, that's your lawyer's job to do your best job. Not to defend like the footage, but just to, you know, defend, basically to prove liability, to show that you were not at fault, that the store was at fault, the way I think this is the one where they stacked the cases, right? You tripped over a case, so maybe it has to be safe stacking, get an expert, you know, whatever they have to do. Yeah, that's the lawyer's job, of course. Liability and damages, they have to prove liability, prove that the store was at fault, and then prove your damages and get you more compensation for your injury. So yeah, that's the lawyer's job in any personal injury case. And then Israel says, does that put pressure on the defense when you're getting funding? No, it doesn't really put pressure on the defense. I mean, you're the one getting funding. So if you're getting funding, then it's actually puts pressure on you, right? Because you have to pay back all this funding. Some people take too much funding. Say they take 100,000, now they have to pay back 400,000, some crazy amount, and it keeps increasing, right? If it's not capped, it keeps increasing, and so the cases take time. It's out of anybody's control. Even if the plaintiff's lawyer is doing everything they're supposed to do, you put it on the trial calendar. Places like the Bronx, you could be on the trial calendar for 4 years. Well, now that 400 could become 700. And what if you only have $1 million policy or something, right? Now, even if you get the full $1 million, how are you going to break that up? The lawyer's going to take a third. 700, but then you owe like 700. So, you know, what's the point? So it puts pressure on the plaintiff. It puts pressure on the plaintiff's lawyer. It doesn't really put pressure on the defense. The defense doesn't care. Well, you know, what do they care? Take funding, don't take funding. A lot of them will ask you if you took funding, but you don't really have to disclose that. But they want to make it seem like, you know, you're taking funding, like the doctors, maybe if the doctors take any kind of, or if you take funding to get your surgery done and there's a lien, then they can make an argument, well, this doctor, of course, is going to come to court and say that you're hurt because he has this lien balance, right? If he says or she says that you're hurt and there's funding for the surgery and part of it is on a lien, then the doctor wants to get their bills paid. They're owed like $50,000. So that's why they're saying that, you're really hurt, because they want to get their money, the piece of the pie kind of thing. And that could be kind of, so you have to be careful with that. So yeah, there's a lot of stuff that could happen that you have to be careful of. And then Kenny says, what is parliamentary hearing Manhattan? Is it a backlog? Oh, I think you mean preliminary conference. Yeah, there is a little bit of a backlog. It's just basically the first meeting with the judge, where you get, basically like a scheduling order, like when your deposition will be, when the defense deposition will be, document discovery. But yeah, there is a backlog, unfortunately. It took us, we had a case in Manhattan, and it took us like a few months, like a long time. I don't know. And then when you write to the court or you make a motion, they say no motions, and you write to the court, they don't respond. I don't know what's going on over there. They have to fix that. There was actually like a CLE about Manhattan with the chief judge, and I watched it, and I thought they were going to talk about this preliminary conference backlog, but they talked about other things. They said, like, if you like are, I forgot what they were talking about, but some other stuff, like basically that they have some facilities in the courthouse. Like if you're an attorney who's also like a mother, they have like places where you could breastfeed. I was like, oh, that's great, but like, what about this backlog? People are waiting a year or more for a preliminary conference, and I don't think they addressed it. But I have to go back and maybe check that CLE. But they, hopefully they're going to have to fix it soon, because it's kind of like absurd. Before you would get a preliminary conference in like 2 weeks. Now people are waiting a year. So Stomper says, what if the plaintiff was about to potentially make a certain amount of money in a trade, but the rec made them stop working in that trade? Let's say potentially I could have been making 30 by now. Yeah, you just add that to your case. That's called loss of business profits. Like basically you were going to make X and now you're not making X because you're hurt. I had that happen in a case. There's also, there's a few different things, right? If you have your own business or your own trade, it could be loss of business income. But if you're studying for a profession, that's different. That's like, basically a future occupation that you can't realize. So it's like in New York, it's called an unrealized occupation. So I had a case like that. I had a guy who was working as a waiter, and he was like driving home, not driving, he was on a bike going home late at night, like at 12, and he got hit by a car and he fractured his collarbone. But he wasn't just like working as a waiter. He also was going to school to become an accountant. And so now with his broken collarbone, he couldn't like take notes. He couldn't, so he had to quit accounting school until everything healed up. And so we made that claim that, he would have been an accountant earlier, and he would have been making whatever an accountant makes, like, entry-level accountant. I think we had back then, it was like $50,000 a year or whatever. And the jury agreed, and they gave us like money for that. I forget how much. And then they gave us like $70,000 or $80,000 for that. So yeah, it's called unrealized occupation, and it's in New York, it's pretty easy to prove. Even like if you're young, if you're like 16, but you're studying to be whatever, something, that you qualify, as long as you could show that, you were studying for that, and there was a likelihood that you would become that profession. It can't be like completely like, I'm going to be like, playing for the Knicks or something. I'm going to be the next Michael Jordan. That won't work. It has to be like, you're actually going to school and you're actually going to be that profession. But yeah, they have case law on it, but it's not that hard to prove. And then Nikisha says, can an injection increase your lawsuit? Yeah, depending on what type. There's a lot of different kinds of injections. So epidural steroid injections, they do. Because if you don't do anything, your case could be worth like 10 grand. But if you do epidurals, now it's maybe worth, 30, 40. Even I've had epidural cases go for like 140,000, which is pretty substantial. You're not going to get 140,000, if you don't do anything. If you just go to the chiropractor, you're going to be like 10, 20. But I got 140 for injection. So it depends on what injection. Now, percutaneous discectomy is also a type of, not really an injection, that's more of a surgery, but percutaneous discectomy could have a lot of value. And then Virgo says, you have a great memory. You're amazing. Thank you. Oh, thank you so much. Yeah. Virgo or anyone else, just text me 347-566-9595 if you want help, because it sounds like she's not happy with her lawyer. So I can maybe try to find someone. I think I did try to find, but maybe the person I tried, I don't know if I tried one or two for her, maybe they weren't able to help for whatever reason. I think maybe the law in that state is a little difficult from what I remember. So if there's any percentage of finding on the plaintiff, then they get nothing or something like that. But we could try someone else. I mean, you know, it never hurts to try. And we have like, we're trying to develop more of a system where we could try to help you. And then Max says, what happens if you fire your lawyer and hire another lawyer? I assume they will still have a lien on the work that they have done. Yeah, exactly. So the way that works, I was actually just explaining that in the consult that I had before the live. I had a consult with somebody. The way it works is, for example, let's say the case settles for $1 million, right? So if you have the first lawyer and now you have the second lawyer, so the case settles for $1 million. Legal fees are, let's say, 33 1/3%. So let's, you know, it's like 666,000 goes to the client. But let's say like 700, just to make it easy for math. Let's say 700 goes to the client, 300 goes to the lawyer. If you have just the first lawyer and you never change lawyers, you get 700, and that first lawyer gets 300, right? Now, if you change lawyers, you have two lawyers. You have the first one, he did, like, let's say, half the work, and you have the second one, they did half the work. You as the client still get 700. That's the client's piece of the pie. That never changes. You could get 10 lawyers. You can get 100 lawyers. You can keep changing lawyers every week. You're still going to get 700,000. But the only difference is now, because you have two lawyers, the first lawyer gets something, let's say 150, and the second lawyer gets something like 150. So they just share the legal fee pie. The legal fee is like a pie, and they share that pie, the legal fee pie. They don't touch the client's portion. That's your pie. You get 100% of that. So that's the only thing. So it doesn't really affect the client. So that's why I was saying, if you can, what you want to do is get the best possible lawyer to get you the most possible money. That's in your best interest as a client. So that's basically how it works. So they have to share it. Now, they can agree on how to share it. If they can't agree, then a judge can do a hearing, and the judge could say, you get X and you get Y, and the judge could split it up. But that's usually how it works. And Nikisha says, I completely my depot, but the driver has been missing for 5 to 6 months. Oh, I see, has been missing. So yeah, you probably want to just, if the driver is missing, you want to make a motion to like preclude them, because 5 6 months, that's a long time. And then just go forward with your testimony. And then you're going to win, because you know your testimony, you don't have anyone else to dispute it. And then Billy says, my lawyer said he was going to do a mock trial after I finished my deposition in July. How long could this take? If I was in another wreck, could this prolong my first case if there's the same insurance? And if I had 2 herniated discs in my back with months of physical therapy and 2 injections and a tear in my hand, would be worth the policy of 100. I was working while getting treatment. Yeah, so he said he was going to do a mock trial. I don't know what that mock. Why would you do a mock trial? I mean, like a practice trial or something, or with like maybe like you meant like a focus group with like jurors to see what they think about it. And then if you were in another wreck, it wouldn't really prolong the first case, but you know it might hurt the second case. You'd have to show that the injuries are distinct. You know, what injuries from the first, what injuries from the second. But yeah, if you have herniated discs and injections, it could be worth 100 easily. 100 is not that much. And Tamia says all injections. Okay. And then Come Along says, I had a labrum tear, did surgery, went through PT while at physical therapy, was in so much pain. The therapist said to get a second MRI, and I had a 4-level slap tear, 250 physical therapies. Oh, I'm sorry to hear that. That's pretty serious. That's a lot of therapies, and that slap tear is pretty serious. That's pretty bad injury. And Junie says I was rear-ended, and the MRI shows the cervical bulge with contact on the cord, and 2 lumbar bulges, causing weakness to my right leg and really bad neck pain. Already received an epidural, going to the chiropractor. They're at fault. They have $300,000 insurance. Can I get the full settlement? I mean, yeah, possible. It depends on what you do for it. I mean, if you just have the bulge with impingement, that just means you have radiculopathy, right? So if you have like a lumbar bulge, or you said cervical, neck bulge will usually travel or radiate to the arms. Lumbar bulge, lower back, will radiate to the legs or travel. That's called radiculopathy. But that's pretty common. A lot of people have that, you know, after a car crash. If you just have it and you're going to like a chiropractor and there's nothing else, just an epidural. I mean, look, the most I've ever settled an epidural for was like 140. So probably not going to get 300 just for an epidural. But if you need like a percutaneous discectomy procedure, which is also kind of minor. It's like a 10-15 minute procedure, but they go in with a striker decompressor and they, remove the leak from the disc. Now with that, it could be 300. I've even had like 550 for that, even over $500,000. So it just depends on what you do. It also depends on where you are and other factors, But yeah, it's possible for sure. Israel says, Mr. Arkady, you're the best. Thank you for your time and sharing. Oh, you're very welcome. Thank you. And then Mistro says, hello. I didn't call him. Oh, okay. Just text me again. Yes, I was away last week, so I maybe got behind, and we're going to make a new system where we, have my intake team help. So when you text, it'll go to like my whole team, and then they'll help, and then they'll maybe qualify the calls. And then once they get qualified, I'll just do the consults, because right now all the calls just come to like this line, like a separate line on my phone. So it's hard for me to sometimes keep track of all of it, because sometimes I get a lot, like 10 in a day, and I can't keep track of all of it. And some people give me their names, some people don't. They're just like numbers, and some are like some spam calls. So it's like, whoa, it's too much with like all the work and trials. But I'll do my best. But yeah, I'm going to make a system so that we, my intake, we have an intake team, and they're very good. So what they can do is when you text, it'll go to like us, and we'll be able to see it, and then we'll be able to like speak with you just to get some information, like, your name, the brief facts of what happened, so we could see what happened, just briefly, and then your injury, your city, when's a good time for a consult. And then we'll have I created like a Calendly link, so you can go in, and I'll have almost like office hours, and you can make your own appointment, and I'll just call you at that time. So I'm going to fix that. But yeah, just text me again. I'll give you a call. I'm sorry about that. And then Billy says, if my lawyer didn't have trial verdicts and I want to hire a new lawyer after I already had a deposition, should I wait after the focus group and see the number? It's up to you. I mean, if you feel like good with your lawyer, you could stay with them. If you feel like, maybe you don't want to use them, then probably the earlier you switch, the better, because remember, the more you wait, then the less chances any new lawyer is going to want to get involved. Because I just gave you that example, right? If it's $1 million, you get 700. The 300 has to be shared by the lawyer. The biggest factor in how they split the 300 or the legal fee is based on the proportionate share of the work, right? Who does what? So if this lawyer is going to do like lion's share, they're going to do 90% of the work. No one's going to want to come into the case, because they're going to say, well, I'm going to come into this case, and then even if I get the $1 million, this guy's going to take like 290. I'm going to get like 10 grand. What's the point? I don't want to. I'll just take a fresh case, right? So that's the thing. It's better to, if you're going to switch, it's better to switch early. So yeah, so that's usually how that works. Junie says, thank you, and I'm in California. Okay, yeah, California, you could get some good verdicts there. And Merle says, crazy story. I found in my court listing where I had a fall in Houston, a lawyer in real estate owns the property. What a mess. Oh, wow, that's crazy. Yeah, so the lawyer owns it. But the insurance will cover it. And then Mistro says, 6 injections, discectomy and laminectomy, loss of income, 2 years off, 200K loss. Oh, I'm sorry. That sounds pretty serious. Yeah, definitely just text me. I can probably do a call like maybe this week for sure. I'll make myself available. And then Carrie says, I had a PRP injection in my shoulder for a partial tear that happened after I had my arm closed in the Metro bus, and I had an MRI and had a partial tear and partial tear. And also physical therapy. Yeah, that sounds like a good case too. And Mistro says 950 policy, so almost $1 million policy. Yeah, so that's a good case. Yeah, 950 policy, that's pretty large. And Max James says, how long does it take? It's been 3 years since I was shot in the head due to negligent security. The punks haven't even gone to trial, and my attorney has done. Let me see here. Something's blocking the. Oh, my attorney has done no discovery. Is this normal? Well, no, that's not good. You want to do discovery, because if they don't do discovery, I mean, whether they go to trial or not, you're talking about the criminal trial, that's like out of your control. But like, you know, your attorney should do discovery if they can do some kind of discovery. You know, I mean, maybe he can't, if he can't depose them because they're still waiting on their criminal trial, maybe the criminal trial has to come first, but maybe the attorney could do something else, like, you know, take some expert depositions or hires people or do some kind of investigation. But if they're not doing anything, that's not a good sign. And then Merle says he got offered $100,000 in Houston for a 3-level fusion, a bone realignment in my foot, and over $200K in medicals, and he's going to pass. Yeah, no, that's kind of low. And then Stomper says, are elevated sidewalk lawsuits going to court till this day? Elevated sidewalks? I mean, yeah, if you have like a raised sidewalk, that's a tripping hazard. That's one of the unsafe conditions. You could go to court for that. You could sue. Usually you'd sue, in New York at least, you'd sue the landlord, the adjoining property owner. Unless it's like owned by the city, then you'd sue the city. And Nicole says, hi, Mr. Arkady. I was in a low collision truck accident, had a cervical fusion and 2 injections on my lower back. Insurance first offer was $125, second was $250. No proof of speed. Yeah, I mean, I would try to get more, even if it's low speed or low, you know, low impact, whatever. But if it's a fusion, it's worth more. And then NV says, no attorney on a PI, lots of issues. Second attorney said the first messed up, they can't represent, and not asking for any money, but the clock is ticking on the other wrongful death claim. Texted you a while back. Oh, yeah, text me again. We could do a call about that. And Max says he said he is waiting for the criminal trial so that he will have a treasure of information, but that darn criminal trial could take 6 years. I had a traumatic brain injury. Oh, wow, yeah. So that's yeah. I mean, like I said, he probably could do some other things while he waits. And Nicole says, what are your thoughts on the offers based in New Jersey? I mean, I think they're low if you had a fusion. Fusion should be closer to $1 million or even more than that, depending on how much coverage there is. So I think you should probably try to get more. Okay. Oh, we've over an hour already, so I better go. But yeah, thank you, everyone. This was good. We had a lot of questions. We had a lot of interaction. You know, please like and subscribe to our channel. Let us know what questions you have. Let us know what video topics you want to see, and we'll make videos about that. And all the best, everyone. Okay. Have a good night. If you have a case, I wish you, you know, the best and the most compensation that you could possibly get. I wish you full justice. And if you're injured, I wish you a full recovery and the best of health. Okay. All the best, everyone. Bye-bye.